Broadcasting from our office in Buffalo, New York, this is the Arrive Podcast, the comprehensive guide to U.S. immigration law designed especially for our Canadian neighbors. I'm Jeremy Richards, your host, along with my co-host and business partner, Christine Jarusik. We bring decades of immigration law experience helping Canadians to live and work in the United States. We're here to simplify the complexities of the U.S. immigration process, answer your questions, and provide insights that only experienced professionals can provide. In each episode, Christine and I will delve into legal concepts, share personal narratives, and bring you insightful conversations, all designed to educate, enlighten, and empower you as you navigate the U.S. immigration law landscape. Whether you're preparing to move to the United States for work, studies, love, or if you're just intrigued by U.S. immigration law, the Arrive Podcast is your resource for making the journey clearer, simpler, and more approachable. So we invite you to come on this journey with us. Listen to the Arrive Podcast. Follow us on your favorite podcast platforms and subscribe to the latest episodes as they are released. And if you find what we share helpful, don't keep it to yourself. Feel free to share it with others who might also benefit from the content. Our mission is to assist our friends from the North in successfully navigating their way to live and work in the United States. So sit back, tune in, and get ready to arrive. This is the Arrive Podcast, the U.S. immigration law podcast for Canadians. Welcome back. So today we are going to answer several of the questions that we've received from our listeners. There's a place on our website where you can go and you can submit a question and you can ask for us to answer it on the show. We've been trying to get people that want to call in live so far. No takers on that. But hey, if you're out there listening and you want to join us live, we'd love to have you and answer your question live on the show. But we do have questions that were submitted by listeners that wanted their questions answered. So we're going to address some of those questions that we've received recently and give them the answers to their questions. So the first question that we're going to answer today, I'll start with the question. Hi, what happens if I get a TN visa? I'm currently on a TD visa. So a TN visa is the primary visa holder. A TD is a dependent. So here a spouse would get a TD. And my husband later gets an H1B. He has a TN currently and has been on the H1B visa lottery for a couple of years. The idea is that he pulls me in with him to get the H1B for a spouse. But will I still be able to work for the employer that has me with a TN? Do I have to quit while switching to the other visa status? So there's multiple questions in here. So we have the question about the TN. Can you go from a TN to an H1B based on your spouse? I think is the first major question in here.
So you can go from TN to H1B, but you can't get an H1B as a spouse. You're going to get an H4 visa as the dependent visa for H1Bs.
So kind of like this TN, spouse is on a TD. Well, if she wants to follow her husband to the H1B, she would not get an H1B. She would get an H4.
Right, so based on her marriage.
Yes. So the downside to the TN and the H1B as a spouse, and I was just talking to a person today on a consultation about this and how messed up U.S. immigration is that not all visa classifications allow the spouse to work. It makes no sense to me. If we're going to let the spouse be here working, why can't the dependent spouse also work anyway?
Right, especially since some classifications do allow it.
Yes, it makes no sense. Like if you're on an L, your spouse can work. If you're on an E, your spouse can work. If you're on a TN, no, you can't work. If you're on an H1B, no, you can't work. Makes no sense.
Well, you can work, but you just need your
spouse
own.
Well, you need your own. But if you're on the dependent visa, and that's what they're asking here. So if you're a TD visa holder,
you can go to school and you can volunteer.
But you can't work.
But you can't work.
H4, same as a TD, you can't work. So could you do this? Sure. But the question here, it sounds like she wants to work under his H1B. You can't do that. She would need her own independent H1B, just like she would need her own independent TN.
And there is a certain point in the H1B to green card process where an H4 is eligible for work authorization.
That's the final stage of the process.
But that's not what she's asking here.
No.
She's not asking about a green card and permanent residence. She's asking about the H1B and the H4.
Correct. And then the other question within this question is, it sounds like she's implying that she wants to hold a TN and an H1B at the same time.
Well, that's not possible.
It's not possible. Now, there are scenarios where you can hold, for example, a visitor visa as well as an H1B visa.
But it's not possible because that is, but the reason it's not possible is because you can't hold two statuses at once.
Two similar statuses at the same time.
Right.
And they're both work visas, so you can't do that.
Right.
You have to choose the work visa you want.
Yeah, and the exception you're talking about is someone who has a visitor visa to the United States. So say you get a 10-year visitor visa, and then while you're holding that, you get work authorization in the U.S., so you can come in and work on a TN or an H1B, but continue to hold that visitor visa.
But you're only using one at a time. You can't use both at the same time.
Correct. So you'd be admitted to the United States in one of those statuses.
Yep. So the answer here is no. You can't do that. You can't hold both an H1B and a TN simultaneously.
Right.
You either have one or the other. So that.
But she's kind of in a good position because she's got TN status, and if her husband moves to H1B, she doesn't need to be tied to his status.
She's on TD now.
Oh, she's on TD.
He's on a TN looking to go to H1B.
I thought she said that she had TN status and she was working. No? Oh.
No, she's asking whether or not she's going to be able to get work status if he gets an H1B. The answer there is no.
No.
But then she also asks if she could get her own TN. Well, absolutely, you can get your own TN.
Yep.
If you qualify and you get a job offer, yes, you could get your own TN independent of your husband or your spouse.
Yeah, just like she could get her own H1B if she wanted.
My other question here, and they didn't ask it, but I would ask them if I were talking to them, is why are you doing this?
Yeah.
It sounds like she qualifies for a TN on her own. He's already on a TN. Why the H1B lottery?
Yeah, why bother?
The H1B doesn't give you an advantage over a TN.
Yeah, I'm not sure why.
H1B has a 6-year limit. Like the TN, you can get at the border. There's no lottery. You can get it immediately.
Yeah, why are you?
It's the same process from H1B to green card as it is TN to green card. Anyway, that's another question that I would ask them is why? Why don't you just stick with the TN?
Yeah, but I think the bottom line with this is if you qualify for TN status and you wrote in with this question, ma'am, you should just go and apply for TN status. TN. And then the good news is that if something happens, if your husband loses his job, God forbid, he would be able to move to TD status on the basis of your TN and stay in the United States with you. And similarly, if something happened to your job, you would be able to move to TD status or H4 status and stay in the U.S. with him while you're looking for a new position. So it's if a couple can have their own independent statuses for work, I always recommend it. Even with those statuses that you get work authorization, if you can qualify on your own, it's always a great thing to do because you actually have a backup plan for your family. In the worst case scenario where a job ends,
and you could have both employers pursue a green card for you, right?
Right.
One pursue for the husband, one pursue for the wife.
Yeah.
And then whatever one goes fastest, use that one.
Yep. So if you're both working parents and you both qualify for a visa, that's usually what I would recommend.
Agree. Okay, now we're going to jump to a recent client that we helped with a precarious situation. So this individual called in. They had applied for TN status on their own. And we see this a lot. This individual had, I can't even remember. It was either 2 or 3 TNs previously. So had been on TN status for a long time under a computer systems analyst, and then went back to the border and tried to get another TN for the same employer and was denied. And the reason for denial was actually a legitimate denial. They did their job and they did it correctly. This individual had a background in computer engineering, but for some reason was getting TNs as a computer systems analyst, and they denied because he was applying under the wrong profession. And the duties were not consistent with the computer systems analyst.
Oh,
the
that
duties
sounds
were consistent
like
with an engineer.
Legitimate denial.
It was. So we were able to then help circle the wagons, file an application by mail with USCIS, correct the deficiencies in the application materials, and then get the individual approved. And they now have TN status again and are able to work in the U.S. And this individual actually has further options down the road if they take advantage of it, where they could potentially get permanent resident status in the United States through a relationship with a U.S. citizen. So bad situation. We're able to rectify it through filing with USCIS after a border denial, and they got approved and are now working here in the U.S. So sometimes
good result.
We can fix it depending on how broken it is. So
Right.
if you have had an interaction at the border, have been refused, let us know. Maybe there's something we can do to help fix your situation. All right, next question. This individual is asking, I've submitted all of my papers 2 weeks ago to the National Visa Center. How much time is it going to take to process the application for an immigrant?
Okay,
so this is immigrant visa
case. I would have a question for this person, whether or not they just submitted the documents
Just
2 weeks ago.
says submitted.
Oh, okay. So they need to wait now until the National Visa Center documentarily qualifies the case. That means they've looked at all the paperwork and they've accepted it all. And then only at that point would it be in queue for a interview and transferred to the actual consulate where this person will process. So they have a bit of a wait ahead of them.
So the way this process works, and we can go back to step one, is you have to file we'll use a spousal case for an example. We don't know what the situation is here, but it's an immigrant visa. So you file the I-130 for your petition for your foreign relative. Once that's approved, then they notify the National Visa Center or the NVC that it's been approved, and the National Visa Center will give a list of documents that you need to provide to them in order for them to then do what you just said, documentarily qualify, and then forward that notification to the consulate here in Canada. We're dealing with Montreal.
Yep.
They'll tell Montreal, hey, this person's been documentarily qualified. Please schedule them for an interview. And then Montreal will schedule an interview and call them in. So if you're not yet documentarily qualified, the NVC could come back and say, oh, you need to submit a divorce decree. You forgot that. Or
we want your full tax return, or we need your W-2s.
Domicile proof. They could miss something here. So we don't know what's been submitted.
And the fun fact is that you may have already submitted all of this documentation to USCIS, but you get to submit it all again at this stage.
And then a third time at the consulate in person. Yeah, it's a redundant process, and it's frustrating. So it's tough to answer this question, but let's assume that everything goes perfectly, that this individual submitted those documents perfectly to the NVC. Typically, within 3 months, the NVC is going to get back to you and documentarily qualify.
And you know what perfectly to the NVC means? It means that everything is oriented in the correct way, that the file sizes are
all four
the
corners,
exact amount of file size that they want. And all four corners are visible and it's completely legible. So,
they have very specific
everything's
requirements.
Translated. All the documents meet the reciprocity schedule. So if this person did it correctly on their own, the
I-864 passes muster. There's proof of sufficient financial support, the tax returns, the domicile. I mean, it's really easy to mess this up.
Right. If this person submitted without an immigration lawyer, chances are at least one of those documents is going to prevent them from becoming qualified first round. So they should watch their email carefully for a message from the National Visa Center asking them to check back in and take a look at a message on their account to see what changes need to be made or what other documents are required.
Yeah, chances of documentary qualification, if you haven't done this before, I would say are pretty slim.
Yes. Although, I mean, I have people call me sometimes that do this process on their own, but I will tell you, they're typically people that immigrated to the United States already. So they've been through this process once themselves and they're petitioning for a loved one. So they're almost, as experienced as someone who's starting out in immigration law and maybe an immigration lawyer because they've been through this process personally. So, I have seen success stories.
So assuming this person submitted the correct documents, NVC reviews them, they documentarily qualify the case. Yeah. We've been seeing cases get from the NVC to interview at the consulate once you submit your documents within 6 months. They're moving pretty quick.
We're assuming they're processing in Canada.
Yeah, we don't know.
They will go to the consulate in Montreal. That consulate in Montreal is the only consulate in Canada that processes immigrant visas. But if they're in another country, all bets are off. So every consulate has their own timelines. And so, we would need to look up the current timelines for the specific consulate in order to give that kind of accurate information.
So immigrant visa cases, you deal with 3 agencies. And that's another thing, right? You deal with USCIS. Everyone celebrates I-130 was approved. Hey, I'm done. No, you're not. Now you got MVC and consulate. So it all depends. But typically within 6 months, I would say the standard case, especially here in Montreal, is going to get an interview.
Yes.
Okay, another case success story. Christine, this was yours.
My L1A applicant. So this individual is actually the owner of a Canadian business, very successful, and it was bought out by a company that had a U.S. office. Their headquarters was in the U.S., and they transferred him to the United States on an L1 visa for intercompany transferee as a manager executive. And so he's been working in the U.S. for a while, and he decided, and his employer agreed that they would petition him for a green card. And so he hired a attorney in his hometown of Montreal who helped him out with that, and it was promptly denied. Then he came to us. We took a look at what was done on the case, and this attorney made kind of rookie mistakes with the application. It's not something you want to really dabble in if you're not familiar with moving L1 to green card. So we assisted him in correcting those errors, refiling the case. He was very skeptical throughout the process that we would be able to make a difference in what was already submitted. But it was a bit of a nuanced case, and so we made the changes that needed to be made. We refiled it, and it was properly approved recently, and this man is now moving on to adjusting status with his spouse and child. So we're happy with that success story for that family.
Yes, the L1A to green card process, or the EB1C green card is what it's referred to as, is much more technical than people give it credit. They think that they just get this L1 and they're automatically going to get a green card now based on that. No, it can be much more difficult to get that approval for that second stage and get that green card.
Same fun fact as the last time, all that information you file with the L1 needs to be refiled with the I-140. Yep. And is re-adjudicated on almost a different level of scrutiny.
Yeah, so they definitely apply a higher level of scrutiny.
I mean, it's frustrating on our end whenever we do this, because if it's done properly in the L1 stage, it's you almost are duplicating the application in the I-140 stage. But in this case, I don't think the initial one was done correctly, ended up getting approved, and then the I-140 was definitely done incorrectly. So,
was the initial L1 done at the border, or was it done by mail?
Good question. I don't recall,
because
I believe it was done at the border.
Yeah. So the border has the standards that are applied by the border are different than USCIS.
Yeah.
So that would make a little bit of sense, and the attorney didn't take that into account when filing the I-140. So if you do a border L1 and then you do a mail I-140, which you have to do, you can't do it at the border.
Well, even this case, I mean, the attorney actually chose the wrong period of time to rely on with respect to his work in Canada, because you have to be in a managerial or executive level position for 1 year in Canada, and you have to identify what 12-month period that is.
It can be any 12 months in the preceding 3 years. It doesn't have to be the most recent.
3 years preceding his entry to the United States. And this attorney ended up choosing, and it's kind of a default sometimes. You default to the 12 months before. The last 12 months before they emigrated or they moved to the U.S. But that wasn't the best option here. In fact, choosing that option disqualified this individual, because he was, once the business was sold, took on a less managerial level position, and USCIS quickly identified that and denied that application. So you got to be careful and work with an attorney that knows what they're doing with these.
Yeah, that's a great example of reassessing and thinking outside of the box, right?
Well, and that's what I mean by like a rookie mistake.
Exactly. You have to know what you're doing and be able to assess it and identify all potential options. So good work on that. All right, next question. My I-140 was approved. So I-140 petition is for, and when it's similar to an I-130 petition for alien relative, but that's filed by the employer. So an employer's petitioning for an employee. My I-140 was approved with a priority date of June 13th, 2007. We can assume a lot with a priority date like that.
That's a long time ago.
Which means this person is probably from a country with a long wait time. I am a Canadian citizen and currently reside in Canada. have no current immigration status in the U.S., so it sounds like this was filed when they were working in the U.S., left the United States in 2012, and held an H-1B with the same company while I was in the country. So there's some assumptions we can make on that too. If they were here from 2007 to 2012, they may have
H-1B?
H-1B time, not much, but they could. The petitioner company sold the assets, however, and I have been providing IT consulting services for another U.S. company since 2022. I am the only person working. What?
So the initial petitioner sold assets?
Yep.
Okay.
Priority date, again, is June 13th, 2007, and then this is where they identify their citizenship is...
Country of birth.
Their country of birth is India, and it's an EB3. And we know the processing times for those are quite lengthy. I would like to know if my company can help me with a green card or if I have to find a new employer and redo the perm. So,
both.
So if the new if your existing company,
because you have to redo the perm.
Not if so here they're
saying
it's not
the
existing same company.
But the initial ones, he said it was an asset sale.
They've been providing IT consulting services to a U.S. company through the petitioner.
Oh.
From Canada, though, so we would need to. That's a tough one to answer.
Yeah,
we don't know a lot about that relationship.
This person some more questions.
What is that relationship there? That's unclear as to whether or not that continuing a relationship would qualify.
But let's answer it both ways. So let's presume that the work is still available and that the initial petitioner is still eligible to continue on with sponsorship.
Go for it.
So if that's the case, if it's current, then this person should,
either
consular process.
Do an I-824 is what it's called, and request consular processing.
Because did they file it adjustment of status? Well, we don't know that.
We don't know.
If they filed it as adjustment of status, then they would need to file an I-824 if they're going to continue on with the same petitioner and get the case changed over to consular processing and processed through the consulate in Montreal because it's the only one that does immigrants.
Yep.
So that's one option. And then the option, you answer this one. What if that petitioner is no longer eligible or the job's not available anymore with that employer?
So the good thing here is that priority date can be preserved. You don't have to get back in line.
Right.
So if you change employers, they will have to redo the perm process for you and do a new I-140, but you don't have to get back in line and start all over with a brand new priority date in 2023. You're able to use that 2007 priority date. And if you're an Indian citizen, that's a huge advantage because it allows you to stay current in your processing. So I just pulled up India's processing times. In India, they're processing cases from 2012. So this individual's priority date is more than current. This person could, if they were in the U.S., let's say this individual came to the U.S. and was able to work for the same employer. Wow, those are some loud sirens. We're on the seventh. We're on the 7th floor, and that sounds like
I was watching them come down the street with all their.
Wow. So if they came into the U.S. and let's say they were able to take advantage of this remaining H-1B time,
yep,
then enter on the H-1B.
Oh, good idea.
And adjust status immediately.
Yes,
you could do that if it's the same employer,
right? Because and the advantage to that is you're going to be able to adjust status, which is a much faster process than consular processing for an employment-based case.
Yes, because you'd have to do an I-824 in this case, it sounds like, which can take several months. And that's where you tell the USCIS to send your case to the consulate where you want to process. That takes a long time. So ideally, this individual would come into the U.S. under H-1B,
so
TN,
ideally, this
status.
was filed for adjustment of status. Let's assume that's the case. And that this person has time left on their H-1B, have another H-1B petition filed for them by the employer, enter on the H-1B,
and immediately file for adjustment.
And immediately file for adjustment.
As long as that U.S. company and the petitioner is doing business and can show they can pay your wages and have professional level work for you to perform under the I-140 approval, it has to be this substantially similar position. If that's still available, then you can act on it. If not, it's not the end of the world, but you're going to have to redo the perm process. You're going to have to do the I-140. But once that's
Which is-
approved, you could immediately again file for adjustment.
It is a lot shorter process than waiting for how many years? From
The current
2007?
11 years. Yeah. Well, their priority is 2007. The current's 2012, but still that's 11 years. So
Yeah.
you'd immediately be able to file for adjustment. So there's a lot here that we would need to unpack talking to this
True.
individual.
True, because
But
if
there
they
are some
filed as
potential
consular
options.
processing and haven't been keeping their case open, that
They
could be
could
an
have closed
issue.
it.
Yeah.
So there's some potential there depending on the exact details of the situation. But that priority date could potentially be preserved, which is huge, especially if you're born in India. Priority date is a big thing.
Yeah.
All right. Another case success. And so this was it was a marriage-based case?
Oh, yeah, my marriage-based case. So we had a Canadian-U.S. couple, and they started off with the consular processing route, but then the husband, who was the Canadian citizen, got a job in the U.S. And so he came into the U.S. on a TN. We helped him with that. And he was working on the TN while they decided to change the process from consular processing to adjustment of status. Now they said, hey, we're just going to stay in the U.S. and adjust status. At this point, I'm on my TN. I can continue to work while I'm going through this, and we'll just sit tight and do that. So we filed the application. But this individual's spouse was not working, the U.S. citizen. She was a homemaker, stay-at-home mom, took care of the family, which is, I shouldn't say not working. That's more work than working outside the home.
Don't tell my wife that.
I've been there myself, so it's a lot of work. But she didn't have any U.S. source income, let's say, other than her husband's income. And they wanted to address the financial responsibilities without having to go to friends and family members. In fact, I don't think they had anybody that they knew that was in a position to act as a joint sponsor.
And a joint sponsor has to be a U.S. permanent resident or U.S. citizen.
Right. So they didn't have anybody in a position to act as a joint sponsor who made sufficient income. And this gentleman made more than enough to support his family. So we were able to obtain a letter from his U.S. employer that stated that he was going to continue to receive that income. They would continue to employ him in that position once the green card was approved. And USCIS accepted that as proof that his employment would continue. And we were able to use the income of the intending immigrant rather than the U.S. citizen to qualify that family. And so now he's here, he's got his green card, and more need for the TN, and everything went smoothly with that. But just so you know, a lot of employers don't like giving that letter, so sometimes it can be difficult to get one. It's not the answer for everybody, but if it's approached properly and you get the correct letter, it's a way to address the I-864 in those situations.
And I will say that most people in this immigration process overlook the I-864 affidavit of support. They rely heavily on the bona fides, right? Is this marriage real? The evidence that they're in a real relationship. But most of these cases get denied on this I-864 because people either don't complete it properly, don't submit the right supporting evidence, and don't really understand the affidavit of support. And so these can get very technical. And
I always think back to that one case I had where they came in. It was a walk-in, and they just walked in off the street, and the wife was crying because they had done everything correctly. So they thought she'd come in on a fiancé visa. They filed the application to adjust status once they got married here in the U.S., and they'd been on this years-long process to get her here, and the case was denied because she checked the wrong box on the I-864. Like, literally, I looked through the application. Everything else was correct. The wrong box was checked, and that was a very harsh result. So it always gives me pause for thought when I'm reviewing them. You know, everything needs to be right here, or else we could have a bad result.
Yep. All right, next question. Now, this person has been submitting questions to us,
wow.
various.
They have 3 questions.
Submitted 3 questions. They're all the same, but they all have a little bit a different angle.
And it's
on
all
the
same
question.
person, huh?
All the same person.
Were they done all recently or over time?
Over the last couple months.
Okay.
So
this is kind of urgent for them then. They must really want to answer this.
All right. So I'll start with this one. I'm trying to determine which one Okay, we'll start with this one. We are Canadian citizens living in Toronto. Our daughter lives in the United States. She's a single mother with a newborn child. We visit her as often as we can, but apparently we are limited to 180 days. Correct. As a visitor, it's typically 180-day max. Can we extend our visit limit by filing for a tourist visa on Form DS-160, or can we just ask for an extension by filing Form I-539? And I'm going to keep reading because they add some more details of stuff that happens. This is actually an interesting scenario. So same individual.
Question one was DS-260 versus I-539.
How do we extend our visitor visa to be with our daughter and our grandchild?
All right, good question.
And the next one, apparently the husband,
the son-in-law?
The son-in-law passed away.
Oh, wow.
And they've since had a grandchild. She's alone and needs help. Can we stay beyond 180 days? Again, the 180-day question. Then...
So that question was just whether they can stay beyond the 180 days?
Essentially, yep.
Okay, so that ties into their first question. How are they going to do that?
And this one adds another layer on top of the same question. They're asking about the 6-month stay limit, but how do exits and reentries impact that? Does it reset that 180-day clock, or is it cumulative for the year, adding up to 180 days each year? What is the maximum time we could stay in the U.S. as a Canadian? So very good question.
Yeah, good question for Canadian visitors.
So 180-day rule, how's that work?
Well, it works in a way that you're only allowed to stay for 6 months in the U.S. So you have to, if you think of it this way, you need to spend more time in Canada than you're spending in the United States. Okay. The snowbird rule, like every 6 months, you need to go back home and stay in Canada for 6 months. The resetting of the clock is one I hear a lot. People, I kind of blame the border officers for this a little bit too, because they're not super careful when they're admitting Canadians.
Rolling the dice.
Yeah, well, Canadians show up at the border. We're not the biggest threat in the world. We're coming back in and maybe we've been here for a few months, went home back to Canada for a couple of weeks, and we want to come back into the United States for a few months. The border officers aren't very diligent, in my experience, in checking out the travel history and doing the math. And I don't blame them. It's not their job. It's up to us as Canadians to keep track of our travel, right?
Yeah.
So that next trip, they may admit you for 6 months again, even though you've got a few months trip already within your 12-month look back period. So one of the questions we get a lot is that 12 months reset on the first of the year. When is it reset? It's never reset. It's a look back period. So look back today.
But your period of stay is reset. That's where it gets kind of confusing, right? Because if you leave the country, and like you said, and a border officer readmits you, they could readmit you for another 6 months.
Mm-hmm. And that happens all the time.
If you stayed here 6 months, left for a day, and came back, well, theoretically, if they want to admit you for another 6 months, they can, and you could stay another 6 months.
Right. But technically speaking,
if they catch it, they're not going to do that, though.
Right.
Most of the time, they're going to say, no, you were just here for 6 months. You need to go back to Canada for a little while. Then we'll let you back in later.
So could it happen? Sure.
Yeah,
but the rule is that, and then the next time you come in, if they see you were here for 6 months, left for a day, and came in for 6 months again, and then left, you're going to have a hard time. Yeah. They're going to ask you to stay in Canada for
a long time.
Yeah. So for at least another 6 months before they would admit you again. So,
if you have vacation properties or whatever it is, you don't want to mess with that.
Well, and you think of your obligations to Canada as well, right? So if you're receiving health care in Canada and benefits in Canada, these kind of things you'll become ineligible for them as you spend time in the United States. And then there's taxation issues as well. So you should be careful. Keep your travel to under 180 days or to 180 days in the last 12 months. And you should never have a problem being admitted to the United States based on your travel history.
So this individual also asked, okay, assuming I've stayed 180 days, but I don't want to leave and I want to extend it. They seem to have
a tough situation there with the...
Well, the DS-160, I'll tell you right now, that's the wrong form. You would not complete that. That's a consular form you use at the consulate. But the I-539 that they refer to here is the correct form. So if you want to file by mail with USCIS to get another 6 months on as a visitor, yes, you can do that. You can file with USCIS and say, hey, I've been here 6 months, give your reasons for stay and proof of financial support, and that would justify you staying as a visitor for another 6 months. And they could potentially grant you another 6 months without you having to depart the U.S. You got to be careful, though, because you cannot depart the U.S. So if you file for an extension of your visitor visa with Form I-539, and then you want to go back to Canada, in the meantime, you will abandon that I-539 application. So that would be only used in an instance that you're not going to be leaving Canada for at least the next 6, or leaving the U.S. for the next 6 months. If you have to travel at all, that won't work for you. The best way to reset your time is to leave and come back.
Go back to Canada for a little while and then come back into the United States.
But again, that can be complicated too.
Depending on how long you've stayed.
Yeah, depending on how long you have been staying here. And it sounds like here it's
and just keep in mind, you
days.
can't file that I-539. So for example, I think the first question we received from this person was a couple months ago.
Yep.
So if they've already overstayed their 180 days, filing that I-539 is not going to be possible because they will be out of status.
This person's also a spouse of a U.S. citizen.
Oh, really?
Yeah. So, I mean, there's more to this that would need to be looked into. I mean, hopefully they filed for a petition for a green card based on that relationship. That's the ultimate solution here for at least the daughter. For the grandparents that are trying to visit, well, once the daughter becomes a U.S. citizen, that daughter could then petition you for a green card.
Oh, the daughter's a U.S. citizen.
The daughter's Canadian, married to a U.S. citizen.
But you said that he passed away.
Yes. So I'm saying hopefully they filed that petition and they can get green card based on...
Well, that's a whole nother...
Oh, it gets complicated. It gets very complicated.
I'm working on a case like that right now that the
petitioner died.
Petitioner passed away, but it was after the I-130 was approved.
Yep.
And, you know, it's become complicated by the consulate not really knowing what to do with this case. So they attended their interview, and the kind of neat thing with it was initially the Canadian spouse was just coming by herself to be in the United States with her husband, but then her husband passed away. And when that happened, she became eligible to add her daughter under the age of 21 to her petition. So now the mother and daughter are coming to the U.S. not to be with the husband, but just to continue on in the immigration process that they started before he passed. So it's kind of that turns into a whole nother story right there.
We just did one similar to this. The U.S. citizen spouse passed away. We did a direct consular filing.
Oh, that's right. I remember that.
Jordan? I can't remember.
Yeah.
It was, I think it was Jordan, and we were able to get a green card through that marriage. So
the consulate in Jordan seems to know what they're doing with those more than the consulate in Montreal, is my experience.
So a complicated situation, and you feel for that family too. That's a very difficult situation to go through. So hopefully they can find a solution to that.
They can file that I-539 and stay a little while with her.
And we just had another one where we did an I-539 because the grandmother wanted to stay and take care of the grandchildren with the newborns.
That's a common question.
And it was granted. They gave it to her. So
you think 6 months is enough until you see your sweet 6-month-old grandchild, and then you don't want to go home, I guess.
Well, my kids are teenagers, so that's a different story.
You don't want to go home either.
All right. So another success story. And we're looking out the window actually right now. It's beautiful.
I'm just watching the truck traffic on the Peace Bridge, and it was all backed up a few minutes ago, but now everything's flowing really good. So
speaking of the truck traffic, that's what I'm talking about.
Oh,
and oftentimes I look over there. This trucking company we represent out of Canada, they do a lot of business over that Peace Bridge. And when I'm driving home, I drive under it, and oftentimes I see their trucks on there. But we were able to help this Canadian trucking company expand their business to the U.S. through an L1 and go through that whole L1 expansion process. And then they grew their business in the U.S. And then the U.S. company was able to then petition the owner for a green card through this I-140 petition process. And then we were able to eventually help him, his spouse, and children all get green cards. So it's a long process, but it was a successful one through the L1 visa, business expansion. Then the U.S. company ultimately petitioned him for a green card. So that's and
I have one with a similar business model, but the applicant, the business owner did not listen to us and did not hire any U.S. people when he started his U.S. company here a while ago and hasn't hired any U.S. people yet, and now wants to extend his status.
Good luck.
Yeah.
Listen to you, and
listen to your immigration lawyer.
That drives me nuts. We have people that hire us for our advice, and then they don't listen to the advice.
Or they ignore it and they think it's optional. But
nope.
The reason we tell people
we don't
to
make
do
up
things,
the rules.
Yeah.
It's not
so
just
now
us.
he's in a tough position. He has a business here in the United States, and he doesn't have eligibility for a visa. We're thinking maybe he can do an investor visa, but it doesn't look like it. So
that's a tough situation. But if you do it correctly, the L1 business expansion to a green card is a great option for those that have companies in the U.S. and Canada and qualify as managers or executives. It's one of my favorite options. Other than marriage to a U.S. citizen, it's one of the best ways to get a green card.
Agreed, 100%.
All right, we're going to finish our podcast today with this doozy of a question. It's actually a very good one. But it's very lengthy, and it's 5 questions in one.
I don't even think I've seen this one yet.
5 questions in one.
Oh.
But it's a good one because it covers a lot of the nuances of a TN visa. Okay,
so TN,
if you're into TNs and you want to know some more about TNs, well, this is a good scenario, good question. So here we go. My husband got a job with a TN visa, and I was given dependent visa, which we've discussed earlier. That's a TD visa. I started volunteering at a couple nonprofits and was offered a job at one of them. So I went to the U.S. I went to get my visa and obtained a 3-year TN visa as a consultant to take the job. Well, first of all, good thing they didn't find out you were volunteering for a couple of nonprofits before you applied for that visa, because that's unauthorized. So be careful. I'm just throwing that in here.
Oh, they volunteered for one of them that sponsored. Oh, yeah,
you can't do that. So be careful if you're doing volunteer work in the U.S. Sometimes that can be seen as employment. Anyway, this individual was then able to get TN status as a public relations consultant. Started work in the United States in May, then quit the job in September after learning, after not being comfortable working at the employer. Now, after quitting, is asking about the grace period. So let's address that one first. Is there a grace period if you lose your job or quit your job on TN status?
Yes, there is. There is a grace period of 60 days.
60 days. So if your visa is still valid, you get 60 days to either file for a change of employer, change of status, or leave the country. Now, that only applies if your visa is still valid. If your visa has expired, you only get a 10-day grace period. So it all depends on where you're at in that situation. But yes, there are 2 potential grace periods. Then just yesterday, or the other day we'll say, I was notified that I was one of 2 finalists for a new job that potentially could qualify for a new visa, and was told that it would be a double W-9 position, not a W-2, and they want to know whether or not they can fulfill that employment. First question is about the grace period. We just answered that. Yes, there's a 60-day grace period to either extend your status under TN, change your employer, or change status to something such as a visitor, or to depart the country. Question number 2. If I lose the TN visa, can I just rely on my TD visa, which is still valid?
It's not valid anymore.
It is not valid is the answer. She did not it did not mention in here that they had a TD.
So she would need to
but you can't have a TN and a TD at the same time.
So if he or she, is it? Do we know?
It's a she.
Okay, so if she wants to revert back to the TD, it wouldn't be.
It'd be a change of status to a TD.
It would be a change of status to a TD, so a new validity period on this TD.
Yeah, that TD doesn't automatically
on the status
kick back in if you lose your job on your TN.
But she still holds a visa in her passport for TD.
Correct. It'll allow you to travel and come back in, but you still need to go to USCIS and change your status from TN back to TD.
Correct.
So you can't just rely on it unless you actually do a change of status from TN to TD. You could also depart the country and come back in and make that change too, whatever's easiest. So you don't have to do it by mail. You could leave the country, go to the border, and they could readmit you in TD status as well. Both apply. Some people don't want to leave the country. So that's that I-539 form that we just talked about for that visitor visa. Well, it applies here too. If you're changing from a TN to a TD, you would file that to change status from TN to TD. Third question. Can I accept this freelance jobs with my TN visa for all the years I was approved for? So that sounds like they want to use this current TN that they were approved for that is valid for 3 years, just work for whoever they want,
No,
even though that employment
they
arrangement
can't
was
be
terminated.
asking that question.
They are.
Well, that is not allowed.
In other words, can I be self-employed on my
no.
TN?
That's a big no.
Big no-no. So your TN is tied directly to the employer that petitions you.
They need to be the ones paying you.
Correct. You cannot be self-employed on a TN.
Right.
So freelance, side jobs, however you want to call it, or even adding a new employer, you can't do it under that single TN.
If you're doing work, you're doing it for the person or the company that sponsored your TN. That's it. Nobody else. If you want to do work for somebody else, they need to pay your employer, and your employer can pay you.
Or you get another TN for that person.
Right.
You have to have a TN that specifically authorizes you to receive compensation from any employer in the U.S. And if you don't have a TN that authorizes that, then you can't do it. So the answer to that is a big no-no. That's unauthorized work. Fourth question. What would happen if right after my 60-day grace period, I'm offered a job and I take it? Well, if you're outside the 60-day grace period, then you're not able to file by mail with USCIS. That's why it's a 60-day grace period. That allows you to file for that change within 60 days. If you're outside, then you need to depart the country and then re-enter.
And then you
apply
could
at the
file
consulate
to change
or at the border before you re-enter the country. But yes, you can after the 60 days. You just no longer have the option to do it by mail with USCIS. It can be done, but it will require you to depart the country and come back in. Final question. Can I accept one of these job offers I was offered? I'm not going to state what the position is because I don't want to disclose too much information. Wow. I'm specially interested in taking one of the positions. Is there a way that I could do that? Or if I get a job as a consultant,
this is a very convoluted question.
The other job. So essentially they're asking if this position they've been offered here would qualify for TN status. And this is
it's hard to know unless we have more information than that.
I'm going to tell you just by looking at it on its face, it's not a TN profession. And it sounds like that's why they went with consultant. And that's what a lot of people will try to do is say, oh, this isn't a TN profession, so I'm going to call myself a consultant. Bad idea. Don't recommend that. Either you're a consultant or you're not. Mm-hmm. Just because your position doesn't fall under TN professions doesn't mean you're now a consultant. That's not the way it works.
Right.
We don't recommend that angle. The border and USCIS are very familiar with that.
Yeah, they're wise to that.
And
for sure.
They will call you out. And they will love to deny you if you're trying to do that. So not something we recommend. If you do get a job offer, however, and it is a legitimate TN profession, absolutely, you can take that job. So there's a lot to that question.
I'm not sure.
We need to know a lot more information.
I feel like our answer wasn't very clear on that.
And question is kind of convoluted.
I know. Maybe we shouldn't have talked about that one.
Well, there was some good stuff in there. We talked about the grace period, changing status, and things of that nature on a TN. You can only have one employer. You need a new TN.
Yeah, that stuff's important to know.
So be careful. In the end, I think what these questions show is that immigration can get very complicated. And if you are in one of these situations, even if it's a simple one, having a consultation with an immigration lawyer is going to clear it a lot up for you so that you understand what you're getting into. And I would recommend that at a minimum for anybody that's doing anything immigration. Even if you think you have a grasp on the situation, talk to an immigration lawyer to make sure. In the end, we may just be reaffirming what you're doing and telling you you're doing it correctly. Good job. If not, we're going to point out the potential issues or scenarios that you might run into if you continue down the path you're going on. And with our knowledge, we do this every day, all the time. This is all we do. we're able to spot things that the average person is not able to. We're able to spot things that many other immigration lawyers aren't able to spot because we are so nuanced with dealing with Canadians. So speaking with an immigration attorney at our office will help answer these questions and provide a lot of clarification so you feel comfortable with the process if you want to do it on your own. And if you don't feel comfortable, well, that's a sign you should probably work with an immigration attorney.
We have that happen all the time. People are doing a case on their own, and then they talk to us and they realize they had been planning to file the wrong form, or were not going to include certain information, or didn't know how to answer one of the key questions on the form. And by talking to us, they realized, hey, you know what? Rather than spend all this money on a filing fee that may get denied if I don't do this right, I'll just spend a little bit more and get an attorney to do it the correct way and not have to worry about it.
And it's not just money, it's a lot of time, a lot of time. And I think that's what most people are concerned about in the end, it seems like, is time. Like, I want to get this fast. When can I get there? Well, if you do it wrong, you're doubling, tripling the time it's going to take.
Right,
so be careful.
2 years can turn into 4.
Absolutely. Well, thank you for tuning in today and humoring us and the questions that we addressed for our listeners. If you do have questions that you want to submit, go to our website, submit them. We'd love to answer them on the podcast. If you have any other questions about U.S. immigration, follow us. We have a weekly email that goes out that contains answers to common immigration questions. We also have frequent updates to U.S. immigration matters. So if you haven't already, please subscribe, and share us with others out there that you think might find this content helpful. Thank you for listening, and have a great day.